I guess we'll start Thursday, whatever we are, October 29th, office hours. We're being recorded and all of that. So this week, again, nothing really huge, I think, on our agenda, and no big announcements. As I was saying, we did a JBCC call public meeting last night, which went well. I do like these virtual public meetings where, in the past I've driven down to the base on Cape Cod, done my 15-minute discussion of whatever topic I have to do, and then drive 2 hours back to go home. So this is so much nicer. I can do my 15-minute talk, answer questions, and then switch over from the computer to my cell phone, go upstairs and grill some bluefish while I'm kind of keeping tabs on everything else that goes on. So there's a lot to be said for this virtual public meeting. Unfortunately, I think there weren't really a huge turnout. I think there were about 45 people on the call, and I'm willing to bet at least 30 or more were DOD, EPA, or DEP staff. So if we can just get the public to these public meetings, it would be good. And I heard the LSPA meeting last night went well. It was interesting, and so I hope to catch up on that on the video whenever that's available.
Nice talk, Larry.
It will.
Thank you. Well, mostly thank Dave and Matt, but thanks, Elliot.
Thanks, David.
Yeah.
Matt.
And the Umass Soils Conference, I also heard went well. And if you didn't get a chance to see it, I'll put in the plug that the recordings of that will be available, I think, through March of next year. So you still have the ability to attend the Soils Conference. So, like I said, a lot to be said for these virtual meetings and conferences, and I hope we're all taking advantage of the ability to take part in them before the scheduling used to be a nightmare.
I'm going to a Michigan talk after this.
Yeah, it's Michigan, Alabama, California, just work your way around the world. I think there's probably a daily PFAS conference or meeting that one could participate in and keep yourself busy from now until all of this is over.
Yeah, that's what the Michigan one is. It's all week long.
Oof. Yeah. Well, I'll put in the plug that the NUMOA PFAS conference will still go on sometime in the further future. They still are planning on that. But not for a while. So I'll open it up to you guys for anything you want to bring up at the moment.
Yes, I have 2 things.
Okay.
Okay. So on the topic of public involvement, the LSPA's December member meeting, which is going to be December 15th, is going to be on public involvement during COVID. So we've got Carol Boyes representing her public sector client, and Lisa Camper, someone from Woodard and Kern, and Corinne McKenzie from Haley and Aldrich, talking about their private sector clients and their experiences and kind of tips and lessons learned and what it's like to participate in a public meeting virtually. So that's going to be for an hour in December. So on that topic, and I'm sure that they all refer to the COVID Q&A public involvement information when they prepared. So I'm guessing that will be referenced. So we're looking forward to that one.
Cool. Yeah, that would be fun.
Yeah.
Yeah, the department is also working on, well, we're working on our public involvement guidance, and also one of the focuses I think we've talked about before is expanding it to include EJ communities, do better outreach, talk to people, get in touch with people that we haven't already. So it will be interesting to hear kind of how it goes.
I think Carol Boyes is going to speak to that a little bit. Her client was and is the city of Framingham, and I know that there was a EJ component there and some community activism, whatever. Anyway, that'll be interesting.
Yes, they have some good sites. For
I just had a thought. I probably shouldn't open my mouth, but would it be helpful to have Karen Stromberg on the panel to represent DEP's perspective?
Well, we did ask about that, and that she wasn't available.
Okay.
So
we can certainly have people there, and and we could sit in the audience and ask the hard questions. But also
send us questions in advance.
Yeah, I may pass along to Deneen Simpson, who is our EJ coordinator and has been working on a number of public involvement outreach pieces. So she might be interested in
that's great.
Sitting in and listening to kind of hear the issues that the LSPs run across and the clients run across. A lot of the work that we've been doing at DEP has been focused, not surprisingly, on kind of the public outreach that we do and how to improve that. So I think it would be good for all of us to hear kind of the challenges and opportunities that the private sector and municipalities and private sector clients and the LSPs have to deal with.
Yeah, I think it'll be interesting. And I didn't know who the EJ coordinator was, so that's good to know.
Paul, is Ellie Donovan still with DEP, or has she retired?
Oh, she's still there. She was at the JBCC meeting last night.
Okay.
So I can say with certainty that she's still with us. Either that, or she's spending her retirement going to meetings, which I wouldn't put past her. Yeah, she's still there.
All right, good.
Yeah. So we could also kind of forward the meeting information to other DEP folks who focus on meetings and public involvement, like Ellie.
She was a great resource for me a couple of years back.
Yeah.
Okay, so then on an entirely different topic, the LSPA commented last Friday on draft asbestos regulations from the Department of Labor Standards relating to mostly the licensing of in the area of asbestos project designers. The regs were more broad than that, but the areas where the LSBA had concerns related to language in the reg, which is 454. Well, actually, it's interesting because the new reg is 454 CMR 28, but the old reg was 453 CMR 6. So that's the one that's slated for replacement. There were a few places where the language was a little broader than what the LSPA would have liked, because it would have required or implied that it would be necessary for LSPs, in order to do some of the site work that LSPs typically do, to also be licensed asbestos project designers. So our letter, which we copied you on, Paul, pointed out those particular areas, and there were three generally. One related to risk assessment and asbestos management planning, one related to signing soil characterization and management plans, and another requiring certain worker requirements for sites where asbestos contaminated soil may be encountered. And we suggested that that language be changed so that basically, every single site doesn't need to be looked at by a licensed asbestos project designer. So anyway, we're going to post this on the LSPA blog later today. So the letter will be available and all that on our website, just on the very first page. But anyway, we just wanted to to bring that to people's attention. It wasn't an area where that regulation isn't one that the LSPA has been involved with before, but we wanted to just make sure that that the folks at DLS understood that there was a possibility that they were getting into possibly limiting some of the work of LSPs. So, so curious about whether waste site cleanup and air and waste, I know you can't speak for air and waste necessarily, are kind of following that.
Well, we are, and I've tried to get word out that those regs were out there and available for public comment.
Yeah.
And so DEP certainly will be working with DLS kind of as we do both in waste site cleanup or and headed by BAW. They have a lot more involvement in these regs, and there's a lot more. So kind of our issues will also be carried along through that. Yeah, I'm not sure whether we'll be like in what form our comments will be, and because it's one state agency to another, so it's a little bit more complicated, or can be more subtle. But yes, they are. BAW certainly has been following along with it as well.
Yeah, that's great. When I Larry Feldman, you know, is our editor in chief, and when I gave him a heads up that this was coming, he said, like, have we ever commented on this before? And my answer was, I don't think so, but we have folks in our regulations committee that are kind of all over this topic, thankfully, and they took a look, and these were important areas, so we have our eye on them, and just wanted to, since we hadn't talked to DP waste site cleanup about this, we wanted to point it out. So there we have it.
Yeah, it's always interesting with, you know, commenting on other state agencies' regulations and approaches where there is that kind of overlap, and recognizing that other people's view of what we do doesn't necessarily correspond exactly to our ideas of what we do.
Right. Actually, someone from our regs committee went to, or listened in on the public hearing, and actually I think made a comment at the end, and you know, it was pretty clear that the role of LSPs hadn't really been considered, and you know, it's kind of understandable. It's easy to, you know, get in your lane and not think outside of it. So we were happy to provide those comments, and hopefully they'll be taken into account.
Yeah. Well, thank you for taking the time
to
do that.
Paul, this is Bonnie. I have another question. I don't know if Wendy mentioned this. When you have internal reviews of these regulations that are not within the Bureau of Waste Site Cleanup, is there, and just internally, it's also going to go to air and waste management. Is there a threshold where there is numerous internal comments and opinions, and that they would put the regs back out for public hearing?
Well, I guess that is potentially one outcome. I think I think there are probably as many different variations on this as you could possibly imagine. In many circumstances where we're working with other agencies, and like I'm thinking of like Department of Public Health, for instance, where often I sit in on some meetings where we'll be discussing, say PFAS in water, and you know, they regulate water bottlers in certain ways, and we kind of overlap on that. Kind of our water interests kind of lead up to the point where they're withdrawing it from a well, so you know, putting in the well and all of that, we have regulatory interest. But then from that point on, DPH has regulatory interest, and DPH has always been very good. We have systems set up because we work very closely together, so that you know, we have a better understanding of how the programs work and work together. So even before draft regulations are drafted, internally, they have I think they often have a very good sense, when it works, when the coordination works, there's a lot of input and discussion right up front before the regulations are even drafted. On the other extreme, you have situations, regs that go out where the agency, and it could be us, we put out draft regulations and we haven't touched base with some other agency that might be affected by it. When we do it, if we ever do it, it's inadvertent. It might be something we didn't realize, that they have a shared interest in this little piece of the regulation. And so then that other agency is playing catch up to us. And, we would take, comments and suggestions from them into account. And I would imagine, certainly in our perspective, if the interaction was such that we would really screw up their program, that it was what we were proposing is really wildly inconsistent, then one result might be going back out for public comment. So I could see a whole range of things, between it being incredibly seamless to recognize as a fundamental problem that results in significant changes that need further public comment, and everything in between. So for these, I don't know. I mean, we certainly didn't. I didn't see the regs, and I don't think BAW saw the proposed regs until they went out for public comment. So whether our comments and your comments and everybody's comments are then result in changes, well, we'll see what happens. And if they result in changes that require to go back out for public comment, then that would happen. But I don't know, and I can't say.
Okay, so it's a case by case basis.
Yeah.
Okay.
Yeah, the threshold for what needs to go back out for public comment, and I'll look to Luke Rogers to jump in, maybe to fill in or correct me. You go out, you put comments out, and if you make changes that are kind of within the realm of what was being discussed, and and there was sufficient and appropriate opportunity for people to comment on what went out, and the changes that come back are kind of consistent with that, or predictable from what you put out, then that's one thing. If it's wildly different, then and nobody had a chance to comment on the specific proposal, and it's wildly different than what anybody saw or could even imagine, then it would, you would really need to go out and put it back out for public comment.
Yeah, that's about it. I mean, there's actually, I mean, this is a little bit sort of, probably want to think about this sort of legal issue a little bit separately from what an agency just might decide to do, given whatever comments it may receive. But there is a legal side to this as well, which many of you may know about or heard about, is that when you put regulations out for public comment, and you get comments and you decide to change those regulations, there's a question that any regulation writing agency has to make, or has to answer, which is, when have they changed the regulations so much that the initial notice wasn't adequate and they need to go out for public comment again? And there are various tests that are kind of floating around. It's any of you who've read case law, you'll sort of be familiar with this kind of case law, where it is a very case-by-case decision, and judges look at the circumstances and sort of call them as they see them. There are various phrases out there as well or tests that courts have articulated, that I won't try to paraphrase right now, something like reasonable foreseeability or something like that. So yeah, I mean, and sometimes agencies will just decide, let's go out again. In other cases, they, whether or not they're meeting that test.
Mm-hmm. I guess it was a very short comment period, and it was not well advertised even within the licensed professions that actually are covered within the DLS for these asbestos regulations. And it was 71 pages and I guess pretty substantive changes. So, and then internally, I think the regulatory committee of the LSPA did a wonderful, a very short turnaround, but certainly didn't have an adequate time to delve into them and how it could affect LSPs, and not just LSPs in terms of the construction industry. The way it's worded, it's almost like everyone in construction would have to have asbestos awareness. So for visibly a suspect asbestos containing materials. So I guess I would hope that there may be a pause to really have internally all agencies that are affected and professions of the have, and maybe look. So that's why I wanted to know the test and who would decide the test. I'm not sure if it would be done on the commissioner level of or it was based on numerous comments within different agencies, or what was received from the public. So that was and it sounds like there are some legal tests to make that decision.
Yeah, I would first separate out kind of, there are legal requirements in Chapter 30A about how agencies put out regulations and requirements for the minimum amounts of time and the timing, the type of notice that has to be done. And and those are out there. Those requirements are known and knowable, and you should be aware that DEP. I can only speak for DEP on any of this really, other than Chapter 30A lays out the rules. Certainly, we always try to play by the rules. Everybody needs to play by those rules and do at least the minimum. I know that there are many times when waste site cleanup, as we put out our regs, and we do this for our own selfish purposes, mind you. But we'll often put out the regs for far longer than those minimums, and we will advertise them much wider than the minimum requirements for advertising. And we do that because we often have large reg packages that are kind of very complex, and recognizing that if we want to get good comments back, then we have to give a lot of time, and that is partly based on how comprehensive the regs are and competing time period, things that are going on like holidays or vacations, things like that. So there are minimum requirements. You can go beyond that. We often do in waste site cleanup, and then the question of how one decides whether to put something out back out for public comment. Again, I can only speak for DEP and more specifically waste site cleanup, but when faced with those kind of questions, I mean, the first people we go to would be our Office of General Counsel and ask them, or I guess, well, our waste site cleanup senior staff, and say, do we really have to do that? Do you think we should? And then we'll go ask. Then we'll go ask the General Counsel's office.
Right, and to be clear, the legal stuff comes in when you're making decisions about how much you're going to change the regulations between the public comment draft and the final draft. So if you, based on the comments you've received or whatever other internal deliberations you've had, if your final regulations are going to be different enough from the ones that went out for public comment, that's when you have to start asking from a legal perspective, have you provided adequate notice? Do you need to go out for public comment again? If you end up, say, some agency X puts out some regulations for public comment, a lot of people don't like them. They comment on them. And this agency X decides that they like their regulations exactly as they first put them out, and they're going to put them out. Then that legal issue doesn't come in because they're not changing them. then if you wish that agency to go out for public comment, again, you would have to be making other arguments than saying that you haven't provided adequate notice. So this is not to provide you guys with legal advice, but again, I just want to be clear how narrow that particular legal test that I'm talking about is. It only comes in when the final regulations are substantially different from the ones that went out for public comment.
Yeah, and that's the danger of what we do in wayside cleanup, which is actually read your comments and to make changes based upon them. Liz is finishing up doing that now for that large set of comments that went out and that got interrupted by COVID and all of that. And that puts us in a position where we do have to think about, okay, are these change? We put out something, we got comments on it, we made changes in response to the comments. Is that sufficient to warrant additional input? You do, as Luke pointed out, you do avoid that if, as many, I see many agencies do, and I was reading an article recently about EPA, I think it was EPA, kind of at the federal level, that somebody in the article I was reading commented that, well, these went out for public comment and they rarely change, after public comment, and they just go ahead and publish what was in draft. And that's often, I think what happens, what you see in draft often gets carried into the final, one might say, despite public comment, or with kind of consideration of public comment, but no changes made. And that from a legal perspective, as Luke said, that if they're finalizing what they put out for public comment, it doesn't open up that it changed too much piece. So, all of, probably far more detail about the reg development and revision process than you want to know. But that also partly explains now why we often put in notes to reviewers that talk about the issue and sometimes talk about kind of alternative ways of doing it, because that not only helps for people to understand what's going on and what we're proposing and what the range of potential options were and why we chose this particular one, but it also helps us because it gives you, the public, the opportunity to comment not only what we propose, but our thought process and kind of other options. So it, I think, and I'm not a lawyer, so I'm going to say, I think legally, and my opinion has no value in this, but I think legally that helps us if we do make changes, because some of those options were put out in the public space and people had the opportunity to read it, understand it, and consider those other options as well.
Well, thank you for a very thorough review.
This is what we do, so we find it fascinating. You maybe less so, but it is kind of interesting. So yeah, we'll talk with BAW. I know they have some comments and some thoughts as well, and we'll see what comes of it. Any other questions? Wendy, you're on a roll, so
I'm done.
that's it. Okay, anybody else as well? So so I want to talk about this is fun, and again, Luke will probably, you can just slap me down. One of the things that came up at the JBCC meeting yesterday that I'm just going to put out there and hopefully not comment too much on is the PFAS issue in the MCL, and kind of interesting thing that we haven't really seen very often before, which is the MCLs. For those, you guys often work on Superfund sites, right? Show of hands, CERCLA sites, and the concept of an ARAR, appropriate, relevant, applicable regulations. And MCLs are essentially routinely accepted as
I'm trying to listen to both because I didn't want to hang up on the DEP call.
Our MCLs, our drinking water standards, are routinely, I would say, considered as ARARs.
It's going on in the background.
Yeah, Marilyn, you're live mic here. I'm going to mute you. There you go. Interesting perspective that the Department of Defense has taken with the new MCL, and not only for Massachusetts, but for other states that have been putting out MCLs, is, and it was described at the JBCC meeting last night by folks from the Air Force, is that at the moment it is DOD's policy to use the federal unenforceable health advisory of 70 parts per trillion for PFAS and P4, rather than the legally promulgated applicable statewide state standards for PFAS compounds, which is an interesting perspective that we have not heard before. So as we move ahead with some of these sites, the kind of role of the ARAR and how it applies, particularly at federal facilities, but all circular sites as well, will be interesting to watch as it plays out.
Is there a rationale for that other than because we can?
I will simply say that it was stated as DOD's policy. And my understanding that when asked for the written policy, they are not available. I think it speaks for itself. So
Yeah,
my
I'm sorry,
commentary
yeah.
on it.
Yeah.
So there's that. So just something that kind of came up that we're watching with interest.
Wow.
So that was the other than cooking bluefish while it was going on, that was the most interesting thing about the JBCC meeting. But they do have that aside, and I would make the point that the people that we work with from DoD on a site-specific basis, are always kind of very, very helpful and generally very productive, and it's a great relationship. It's when kind of one finds oneself implementing policies that come from elsewhere that it becomes difficult for folks.
You feel that, so that's a national policy, national DOD policy?
Yeah, we're seeing that in other states as well, that that it's becoming an issue. So very, very interesting.
Wow.
Paul, this is Mike Cronin. Can you hear me?
Hey, Mike.
Hey, how are you?
Oh, not bad.
So I had an interesting thing come up this week, and I'm kind of curious about it. I had an attorney for a client ask me if I would sign the waste site cleanup forms, not only as LSP, but as agent for the PRP. I looked up in the MCP, and it says under 310 CMR 40.009 that is allowable, silent on other parties signing as agent on behalf of the PRP. And I'm curious about the genesis of that and under what circumstances and how I actually sign an agent for the PRP.
Liz, do you want to comment on?
I'm getting hung up on the word agent for the PRP. I know we have provision to sign on behalf of the PRP, and I thought that was for convenience for multiple submittals, that once PRP started working with an LSP, that they could just skip that step of having to get the two signatures on things.
Yeah, I seem to remember early on, particularly with kind of less computer savvy PRPs, that we would get letters designating somebody else, often the LSP, but it could be anybody, to sign on behalf of the PRP. The stories we heard were people having to bringing laptops, to the owner of the property who didn't have a computer themselves, and sitting down and doing it with them, it just became easier for them to designate somebody to sign on their own behalf.
The only thing to remember is to get it in writing. Have them send you a note or an email or something that officially asks you to sign as their representative.
And I would say if they already have an attorney involved, why not have the attorney sign for them instead of the LSP?
I don't think we have a provision
That
for
was
that.
where we ended up. Our legal counsel, our internal counsel advised against signing, and I'm personally just not comfortable signing on the PRP and wouldn't do so without some sort of agreement in writing. But my understanding was that perhaps it was due to people not being able to get it, or
Mike, we're having trouble hearing you. It's like a piano is playing every other word.
Yeah, I just looked at that language briefly, and I'm not sure that language was really designed specifically to facilitate a kind of a principal agent type relationship. Really, I'm guessing, and Liz and Paul can correct me, that what we had in mind when we drafted that language was situations where you had a legal owner, an entity that is a legal owner of property, like a corporation. And so you always have to identify the right person who can sign something on behalf of a corporation or a trust or an LLC or what have you. And so we have some boilerplate language that basically requires the person who is actually doing the signing attest that he or she or they are authorized to sign on behalf of that legal entity. Now, if somebody wanted to argue to extend that to kind of a principal agent relationship, that's something they could think about, and it's not something I've really thought about. But again, I'm not sure that language in that regulation is designed specifically and explicitly to accommodate that kind of situation.
Okay, you looking at the, when Mike started this question, I thought he was talking specifically about submitting the forms on EDP.
Right.
As opposed to actually signing, within the form as to the representative of the agent. They're two separate things. A representative of the PRP, I mean.
So we're not looking at the same text. I don't know if we're looking at the same language right now, but I'm just looking at the language in quotation marks. It's the second paragraph of 0009, certification of submittals, where it says, I am fully authorized to make this attestation on behalf of the person or entity legally responsible for the submittal. So is that the language that you were thinking about, Mr. Cronin?
Yeah, that was the language I was looking at, but it was also the citation. I think it's paragraph 3, where it talks about the LSP being able to sign on behalf of the, I guess, the PRP. I don't have it in front of me, so I'm going by memory.
Yeah, Mike, you're talking about paragraph 3 in the form? Or
no, paragraph 3 under section 09 of the MCP.
Oh, okay.
Yeah, that just says, the written declaration required by 0091 shall include the signature of each person making the submittal, the date on which each such person makes his or her attestation, and the position or office of each such
No,
person.
I think Mike might be referring to paragraph 2.
Paragraph 2, and it says the written declaration shall not be made by the LSP engaged by the PRP unless the LSP's client or employer has authorized him in writing.
Yeah.
Right,
That's it. That's the one. Thank you.
Yeah.
So whether you do it or not is up to you, right? I mean, if your client, if your client asks you to do it, you could say yes, you could say no. If your client's lawyer asks you to do it as an LSP, you can say yes or you can say no.
And as Larry said, in writing.
Yeah,
make sure
and,
it's
and if I were asked to do it, if I were an LSP, I guess I would be sure I had sufficient evidence of being authorized, to do that in whatever form.
Good. No, agreed. Thank you. We have politely declined, and I don't think as a practice, hey, we want to do that. Our company wants to do that.
Yeah, Mike, I'm assuming you're not dealing with the homeowner, not computer savvy. They don't have access. They're confused by EDP. It's probably a different situation.
That is exactly the case. They're very capable of signing. So I don't quite understand the reason for the question, but have, again, politely declined at this point.
Well, that was an interesting.
Sounds like a good choice to me.
Okay. You guys are on a roll. Any other questions?
Oh, I had a question about PFAS and GW3 standards.
Okay.
Okay, so in terms of the MCP and evaluating when you have PFAS detected in surface water or you actually, and there may have been PFAS detected in groundwater, and looking from a ecological protection of aquatic life. And what, shall I say, scientific basis that you may, or the Bureau is thinking for coming up with like benchmarks in which to derive GW3s.
So this is the where do those numbers come from question?
Yeah, and there's a variety of numbers or literature values out there. ITRC, SERP, Michigan, Minnesota. So what exactly is the department or the Bureau looking at of finding acceptable, and is there going to be any discussion on how those are deemed, peer reviewed and acceptable? So just would like to know the process.
Yeah, well, a couple easy answers, some of which will not be really satisfying. I'll start with the non-satisfying one, that if you do want to get into the details of kind of which peer-reviewed studies would be appropriate, et cetera, to do a site-specific risk assessment, then I would say call Nancy.
Okay.
Because the limits of my knowledge of the ecological risk-based PFAS concerns is pretty much at this point limited to, we have GW3 numbers. I know that the GW3 numbers were based upon a literature review at the time, and they settled on the numbers. I think it was Michigan had them.
Mm-hmm.
It might be one of those M states like Michigan or Wisconsin.
I thought I don't know. I thought it was Minnesota, but I'm
or Minnesota. One of those Midwestern states. But that were published, and we use those values as the basis of the GW3, and that is knowable. That's documented in the spreadsheets. You can go in. I was looking for my copy of it, and it wasn't really handy. Otherwise, I would have spoken even more knowledgeably about it. But that, of course, was at that point in time, given what was available. At some point in the future, those GW3 standards might and will probably change. And if you're doing obviously a site-specific risk assessment, then you would look at what's available now for that. And Nancy would be able to help you. I believe they're keeping up on that.
Okay. So the Bureau is open to other acceptable scientific literature, peer-reviewed, if you're going into a site-specific situation.
Yeah.
Okay.
Yeah. I mean, it works the way it always works, that you know, because the GW3 standards are in regulation and also form the basis of the RCGW2. I mean, they are what they are, and they apply as long as they are in the regulation. But if you are moving to a method 3 site-specific assessment, then, you know, don't put on blinders just because we use that particular number back in 2018 to derive the GW3 standards at that time. It would be whatever would be most appropriate.
Thank you.
Anything else? Diane Phillips, we haven't heard from you at all. Charles Young, we'll start calling.
Just listening today. Thank you.
Hey, Paul.
Are you still on the Cape, Diane?
I am, and I'm watching Wellfleet Harbor dredging that's 24 hours a day, clunking away in our front yard. It's interesting. It seems very slow going, but they say they're ahead of schedule.
Navigational dredging?
Yes. Yeah, it's the nav channel. And then I think the town is going to try to do the marina part if there's time left. But it only, they're only dredging to 10 feet out here. We don't want any big boats out here.
Well, Michelle knows all about navigational dredging.
Yep, except I don't have to live next to it.
Yeah,
thankfully, our house is pretty soundproof, so yeah.
So, anything else anybody wants to talk about?